Right out the gate, this judge isn't holding back. Look at that reaction. Courtroom 101, appearance matters. And showing up to court dressed like it's a beach party? That's a surefire way to lose credibility before a single word is spoken. The jury won't even hear your story if your outfit screams, "I don't care."
Gordon, please.
Tom Kelly, Adam.
2341393.
I believe, Judge.
You can't make this stuff up, really, Tom.
No, Judge,
God
you
bless.
can't.
I know that's so unlike you. Really? Really? This is set for trial. You think you're going to impress a jury? Dressed like that, sir? You look like this is a clam dig. This isn't a clam dig. Really? You really? All the jurors are going to be dressed in ties, well coiffed, neat, and this is how you're going to impress a jury? It's jury day. I mean, we could call you right now and pick a jury here at 1 o'clock. You think that's? Do you wear that to church, Mike, for example? That's not funny. It's not funny. This is basic stuff. Actually, you can dress any way you want, but it's foolish to dress like that in court. Two things. You either don't understand and appreciate intellectually the importance of what's going on, or you really think it's not important and it's not, there's no reason to be respectful. Either of those are bad choices to make. All right, why don't we try this today?
I can try it, Judge. I'm ready.
Y'all ready?
Not try today, Judge.
Okay, why? On this one? What, did you have a resetting on? Did you have a motion?
It's filed Friday, Judge. You may not have.
Next was filed Friday after I worked with the.
This moment is more than fashion advice. It's about courtroom psychology. Judges' red attitude through presentation. A sloppy look signals disrespect or ignorance of the process, both fatal mistakes. Remember, in court, perception is persuasion.
Files.
Tip me off on this. Call me. You know, you're gonna get some slack. Just let me.
I understand.
Something came up.
And it's certainly
Something came up at the last minute.
not our
Well,
habit to
I mean,
follow.
it's. Okay.
As I stated,
Do you
Judge,
retain on this?
I am.
Well,
I have no objection to him having time, Your Honor.
How long have you been representing the defendant?
72 hours.
You've only been representing for 3 days?
Yes. You were hired Friday. What I was trying to say was it's not our practice to
Okay,
not
hold
tip
on.
the court off 3 days before trying to send it.
Hold on. Who was the other one?
Langston was Judge.
Oh, okay. The way I was reading this. Okay, Langston, you're being substituted. You knew that.
Yes, sir.
Because until I sign this, you're still up. But you're not gonna have a year or 6 months or anything like that to
6
prepare.
months is sufficient.
Okay, I'm gonna restart for 6 months.
I'll really shoot this guy in a minute. The good thing is it wasn't an evading charge. You're that sure.
What's your bond right now? You don't know? You don't. Every defendant I know of knows what the answer is to that. Yeah, yeah. Why did I up it, do you think? Because you tested positive for cocaine and marijuana in court. See any good reason to do that, you think? That was just in what, May? I'm not surprised. I'm not surprised you make decisions like this when you're making other poor decisions, like let's use cocaine and marijuana. All right, I've granted your request, and I find good cause, Langston. You are released. We're going to set this for trial soon, though. This one is one that shouldn't be a real problem to get tried quickly. Looks like it's pretty succinct, so it'll be set in a few weeks, please. And you're going to get a resetting. You're the lawyer. He's going to get drug tested again. I don't trust him. Lance Dixon. Yeah, Lance Dixon, please. 23-41449.
Boom, there it is. The judge hits him with the results. Positive for cocaine and marijuana. And that's not just bad optics, it's a violation of bond conditions. Judges take this as a direct betrayal of trust. Notice the tone shift? We're moving from frustration to consequence.
He's tested positive twice while on bond.
That's fine, okay.
Thank you.
And we have to try that one. Gonzalo Alvarado, we say that's ready.
Your Honor, this is the equivalent of a murder case. The death on this is the death of a 2-year-old, and this lawyer is not ready.
Go ahead.
Yes, Your Honor, we filed a motion for continuance. We are actually approaching as well for investigator funds. Mr. Gonzalo originally had a court-appointed attorney. The family got.
I don't have anything in this file. You must have just filed it.
I did,
Well,
and I do apologize, Judge. I
It's probably after I worked with the files.
But you hadn't been on this long, right?
No, Your Honor.
How long?
1 second.
This is the first trial setting, but he's been on it for a few months, Judge.
How'd you file it?
Did you e-file it?
Yes, I did.
Okay, I don't have it through e-file yet.
I have a copy.
What is it you're asking for?
Judge, we're asking for investigative funds.
Wait, are you retained?
I am retained. I understand that could be a problem for the
That is a
court.
problem.
Mr. Alvarado has expressed that his funds and the families here as well that have been were used for counsel.
That's his problem. I mean, y'all figure it out. That's not the way it works with me. I'm sorry. Y'all got to figure it all out. If he's either going to retain counsel, but it's not hybrid where the
Yes, sir.
county's paying the counsel if it's retained. If he can't afford to get this done, he needs to have an appointed lawyer, or you work in a different way. But it's
And just to
we're
be
not
clear,
paying.
sorry.
We're not going to pay if he's getting retained lawyers. But I
and
mean,
this is.
we've
sorry,
tried
Judge.
600 jury trials here now. Nobody does that more. I've never done such a thing. It's never been asked before. But I'm not going to open that door. Every lawyer in this room is retained, would rather see the expenses paid by the county, which you're going to have to show me where that is allowed. Because I've never heard of him. I've never heard of such a thing.
So, and I understand and I respect the ruling of the court, Judge. I just want to confirm it's not for counsel funds, it's for investigator funds. And if the court's denying it, we respect the court's decision. I just want to make sure that that's
Yeah,
correct.
I need to see the thing anyway, but I'll review it. But if there needs to be something that shows something unique and special about the situation,
Yes, Your Honor.
because I opened the door for one, I opened the door for everybody.
Understood.
And there's not a retained lawyer who wouldn't file the same motion and go, I want Mr. Alvarado rule, the Gonzalo Alvarado rule. You open the door, what's fair, it's supposed to be fair in this room, and it is, but I have never had special fees for retained counsel paid by the county.
Understood, Your Honor.
I'd rather not open that door, but I'll see what you have to say. Otherwise, and then it was set for trial. See, anyway, we're at. I mean, it's not that long compared to some other stuff.
Yes, sir.
They're struggling. But anyway, that's it'll be rotated around for trial in 6 weeks. Can you be ready in 6?
With the investigator issue, Judge, there might be a concern that we'll be ready within 6 weeks. We would ask for additional time, but as always, we
What are you
respect the-
thinking you need?
Maybe 4 months.
4 months? No. I'll give you 8 weeks. Okay, for 2 months.
I mean, again, 2 months, that's,
I don't know where I put it, they're gonna put us in mid-November, doesn't it? Close. Anyway, 2 months, okay?
all right, Judge.
8 weeks.
No,
Respect the court's rule.
Yes, sir.
this does involve the death of an infant child, so if the court is considering that length of time, I'm asking for some special setting since he's out on bond.
I don't know, what do you mean a special setting?
I don't
8
want to,
weeks is 8 weeks and we'll set.
Okay, let's pause here. This is a fascinating legal debate. The defense lawyer, privately hired, is asking the county to pay for investigative costs. But here's the catch. That's usually reserved for court-appointed cases. The judge's stance? If I open this door for one, I'll have a line of lawyers outside tomorrow. And honestly, he's not wrong. What do you think? Fair ruling or too rigid?
For 8 weeks.
all right,
How's that? I guess that ought to give everybody a lot of time.
I'm ready now, I'll be ready then.
The length of time you're expecting, a week?
I don't think that, it should be done within a week based on the number of witnesses.
I would agree, Judge.
Your motion, you might want to look at your motion. I haven't seen it. You might want to look at your motion and maybe
Give me some
tailor it.
specific. Yes, Your Honor.
Yes, sir.
Understood.
Okay.
Thank you
Thank
very
you.
much, Judge.
Yes, sir. Jonathan Ramos,
Okay, all the-
Ryan,
I haven't heard from you.
that was, did we resolve that already?
We're gonna release it, Judge.
No, that's what you said. Where's Mr. Ramos?
I've reached you.
Reset. Zachariah Atterbury, Dan and Langston.
Atterbury is the one that Mr. Adams has filed a motion to have him evaluated. And Godot is the one where Mr. Roebuck is absent.
Okay, okay, and. Yeah. Hey, Langston, once again, I don't have here's this. I don't have any motion, Langston, from you on Atterbury. Where's Mr. Godot? Anthony Godot, please. On 24/2/77. Were you appointed on this one?
Yes, sir.
Langston?
I am.
Thank you.
I can get you some more.
Okay,
information.
yeah,
I can do that.
I mean, this doesn't give me anything.
I-
There is no articulated reason other than your belief, which it needs to be supported by facts.
I can do that.
So I can't grant that at the time.
I can do it.
On Mr. Gordon there, he flunked the drug test.
What do you have?
He's got marijuana in his system. Yeah, I don't look, I mean, like, I can't believe it's not butter. It's, you flunked the drug test and that's your third failure. That's your third failure. Yeah, you can have a drug patch. The drug patch isn't going to make an alarm and ring bells. The drug patch is taken off and then it's sent for inspection. We've tested your urine and that's pretty positive. So we just get a resetting,
Thank you.
but only for like 4 weeks on this one, so we can rotate this thing around. I
Yeah.
want to see where we are on getting everything done, but
I
get
can work on
this
it. I can,
quickly. Thank you.
thank you.
And on Mr. Roebuck, on Anthony Goodo, come on up. Mr. Roebuck is ill, I believe, today. I don't know if you heard that,
He's in pneumonia.
sir.
Pneumonia.
Well, you know more than I do. Yeah. Well, you don't want that. So get a resetting. We have to reset that, sir. Thank you. Now come on up, Mr. Gordon. Here's Mr. Goodo's. Langston Adams, come on up. I don't have Mr. Gordon.
It's the one that
I don't-
really substitute.
Oh, okay, okay.
That paperwork right here.
Oh, no, I was looking for his phone.
You do have one of that.
Here.
Oh,
I think it was gonna be reset. I think that was the plan.
That's the reason why I reduced it.
All right. Thank you. You building up a rich history here in just this case. You tested positive for marijuana back in June 12th, which was 2 weeks after the cocaine and marijuana positive in May 29th. What is this bond now?
it's $60,000.
It's doubled to $120,000. Your bond is revoked. You are taken into custody. You will continue. Don't interrupt the court. You'll have a chance to speak, but your lawyer would tell you not to say anything. Your bond is revoked, and it always doubles. It always doubles when you fail a drug test, and you must continue to have a drug patch, and it will keep going up. It will be costing. It will continue to cost you, but the rules must be followed in this court. Do you understand? Taken into custody. That is something. And tell the attorney that his lawyer's in custody now.
The defense pushes for 4 months to prepare a case involving the death of a 2-year-old, and the judge slashes it down to 8 weeks. You can feel the pressure mounting. 8 weeks to prepare for a potential life-altering trial? That's the ticking clock of justice.